advised the Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. I am Judge Ferruia. To my right is Judge Campbell, and to my left is Judge McMurdy. And we are here for oral argument in our case number CV 22-0224, TP Racing versus the Arizona Department of Gaming. As you may know, we record and live stream these proceedings, so please give your name and the name of your client before you begin. You have a maximum of 20 minutes per side, although you are not required to use all of that time. The clocks in the podium are there for your benefit and use. Just please be aware that any time that you wish to reserve for rebuttal is also reflected on the clock, and it is your responsibility to keep track of it so it's there for you to use. Please also keep in mind that we have read the briefing and we have studied the record. We have discussed this case in conference. And with that in mind, counsel, you may begin.
May it please the Court, good morning. Conley Schulte with the firm of Peoples Kidders on behalf of Appellant TP Racing. With me at counsel table is Craig Keller with the firm of Gus Rosenfeld. At this time, I'd like to reserve 5 minutes of my time for rebuttal. The Arizona Department of Gaming has publicly represented on its website for years that Turf Paradise is one of Arizona's first sports franchises. So TP Racing, which owns Turf Paradise, was rather shocked when the department denied its event wagering operator's license on the ground that it was not an Arizona professional sports franchise. Further surprised that the director and the Superior Court affirmed the decision on those very grounds. So the common error
how much weight does that have? The fact that they listed on their website.
Well, Your Honor, it doesn't have the weight of a rule or a final agency action, that's for sure, but it certainly is persuasive, and certainly, having made that statement over the years and that is consistent with the law in the matter, we believe that it's persuasive. And
was it listed or published before or after the legislation was passed?
It was published before and after. I believe it's still being published.
Well, point being is that they put it on the web page long before the legislation took place, correct?
That is my understanding. That's correct, Your Honor.
So you're telling me that some administrator of the Department of Gaming, once the legislation is passed, didn't have the foresight to think, oh, it doesn't qualify as a franchise anymore. Maybe we should change that. Should have some persuasive effect?
I believe it has some persuasive effect and also affects the credibility of the positions that are being taken by the department now, because never once in the proceedings below or before this court has the department informed us, what it meant by that statement on the website, if it means something other than what it says now constitutes a professional sports franchise.
Okay.
So the common error that runs throughout the department's arguments and throughout the Superior Court's decision is that they rewrite the language of the statute to narrow the definition of a professional sport so that it only applies to team sports, and to limit the term professional sports franchise to include only franchises that have a right to field a team in a league. But in doing so, they ignore the bedrock canons of statutory construction and, quite frankly, contradict the plain language of the statute itself. But it's not the role of the department or the Superior Court to rewrite the statute, and it's the role of this court to interpret the statute as written. And when it is interpreted as written, it's clear that Turf Paradise is the owner of a professional sports franchise and therefore qualifies for a license. So we raise two issues for review in this appeal, and first is whether the Superior Court erred in determining that the horse racing conducted by TP racing is not a professional sport as defined in the statute. And second, whether the Superior Court erred in determining that TP racing is not the owner of a professional sports franchise. The Event Wagering Act defines a professional sport as, quote, a sport conducted at the highest level league or organizational play for its respective sport, and includes baseball, basketball, football, golf, hockey, soccer, and motorsports. The Superior Court first held that the horse racing conducted by Turf Paradise does not meet that definition because, quote, it is not the owner or operator of a sports team, close quote. But the error in that determination is that the definition of a professional sport under the Act doesn't even mention the word team, and it expressly includes as non-exclusive examples of sports teams that are not played, or rather sports that are not played on a team. That determination also is contradicted by Section 1304, rather A1, which authorizes licenses to owners of professional sports teams or franchises. You know, because those two terms are separated by the term or, the canons of statutory construction require that they be given separate and distinct meanings, and the determination by the Superior Court simply does not do that. It ignores the term franchise and requires that in order to qualify for a license, you have to play on a team. And that brings me to my second point, and that's the Superior Court's determination that the horse racing conducted by Turf Paradise is not a professional sport because it does not involve, quote, organizing by teams themselves or competition among teams. Again, the word team does not appear anywhere in the definition of a professional sport, and it suffers from the same errors as its determination that was previously discussed. Which brings me to my next point, and that is that the court erroneously held that because horse racing is regulated by the department, it does not meet the statutory definitions of organizational play. But that ignores that the definition of professional sport, in that definition, the team organizational play is modified by the term for its respective sport, which is an acknowledgement that, different sports are organized in different and unique ways. The sport of horse racing, professional horse racing, has historically been heavily regulated by the state, and that's because it has historically involved gambling. The racing regulations impose a whole host of requirements upon the track operators, one of them being to employ a racing secretary whose duty it is to organize the races such that the horses in each race are of relatively equal skills and abilities so that it's a competitive race. So, in part, the secretary, employed by the track operator, organizes the sport. And the record also establishes that professional horse racing is in part organized by the participants. As the department acknowledges in its brief, the track operator, the owners, the trainers, jockeys, they all have a part in determining who races where or what horses races where and when. But that is how the sport is organized. It's organized for its respective sport and thus qualifies, fits squarely within the definition.
Is there somewhere, counsel, in this record that TP Racing has horses that it fields at its track?
No.
It owns, or does it sponsor jockeys that it is in charge of? It's a TP jockey.
No, I don't believe that is reflected anywhere in the record.
Okay.
And I'm not aware outside of the record that would be true either. Now, the Superior Court also reasoned that horse racing is not a professional sport because in a separate section of the Act, limited event wagering licenses are authorized for owners of racetrack enclosures. Excuse me. But a little bit of background on the limited licenses. They're far less valuable than a full license. Unlike the full licenses where the licensees can accept bets over the internet from anywhere in the state, whether a bettor wants to place a bet on a cell phone or a laptop. Under a limited license, the operator can only accept bets on site at a racetrack or at an off-track betting facility, rather. And so they're far less valuable. The universe of potential bettors is very, very much smaller than would be under a full license. The Act also requires a limited license holder to partner with a full license holder, and that comes at a steep price. So the limited licenses are far less valuable. But if the legislature intended to exclude owners of horse racing facilities from holding a full license, it would have said so in the statute.
Wasn't by the definition of which are included. I mean, you listed a whole cadre of basketball, baseball, this, that, motorsports. Why didn't you go to the legislature and have them put horse racing in there if that was critical to your business model?
Well, Your Honor, this legislation is kind of unlike any other piece of legislation in how it came about and how it was enacted. The legislature did not have any role in drafting the legislation. It was negotiated between the governor's administration and the state's Indian tribes over a period of several years, behind closed doors, subject to confidentiality agreements. And the result of those negotiations were the bill that was the Event Wagering Act, and it was introduced in the legislature exactly as it was negotiated and concluded by the governor and the tribes. It was then passed through the legislature with ludicrous speed. It was introduced in February and it passed the legislature in April with very little debate. So there was very little opportunity, and I don't think there were very many amendments to the bill. I think mostly minor technical amendments were made during that time. And it was passed with an emergency clause. I guess sports betting is an emergency in Arizona. But so there was very little opportunity, really, to get any amendments made to this bill. And I'm not aware that my client made those efforts or not. But it's a good question. And there's a perfectly reasonable explanation for why the legislature would not exclude horse racing owners from a full license while making the limited licenses available. And that's because there's only 10 licenses available in the state. So there's certainly a good possibility that there's going to be more applicants for those 10 licenses than there are licenses available. And it could be that, even though the racetrack...
But they haven't even used the ones they've got, have they? They haven't issued the licenses they've got, have they?
I believe they've issued 8. But, at the time the legislation was, put together, I don't think anyone knew how many applications there were going to be. And so it was a possibility that, racing franchise owners, though qualified, would not be selected as one of the 10. So the limited licenses sort of act as a backstop, so to speak, so that the racing industry has some benefit from this legislation, albeit not much compared to the full license. So in sum, the mere availability of these limited licenses in a separate section of the statute does not in any way preclude racing franchise owners from holding a full license, particularly when they qualify under the plain language of the statute.
Do you know, counsel, if a full license holder can hold both a full license and a limited license?
Well, it's my understanding that if you're granted a full license, there's no need for the limited license because you can accept wagers both on site and over the internet with a full license. So if Turf Paradise or TP Racing were granted the full license, it would have no need for a limited license. And that brings me to my second issue for review, and that's whether the Superior Court erred in finding that TP Racing is not the owner of a professional sports franchise. Now, neither the Act nor the Department's regulations define the term franchise, much less sports franchise. But again, the Department of Gaming has publicly stated for years prior to the enactment of the Act that Turf Paradise is one of Arizona's first sports franchises.
Isn't the question about whether or not, for purposes of the statute, whether or not TP is a franchise is a question of law, isn't that? Isn't that?
I believe it's either a question of law or a mixed question of fact and law.
But the point being that if it's a conclusion under the law, if it's a legal conclusion about what the character of TP is for purposes of the statute, isn't it kind of irrelevant what DOG is saying on its website?
Well, the Department of Gaming is charged with having expertise in gaming, and horse racing.
Yeah, but our statutes say we're not even supposed to give them deference in that regard.
Understood. But the department's statement is also consistent with other authorities on this precise issue.
I think there was some statement in the briefing that language actually comes from TP itself. Is that so?
Well, the record does not indicate whether, who said it first, right?
Is that language on TP's website?
It is.
Okay.
And neither party attributes the statement to the other, so it's unclear from the record, who said it first. But bottom line is the department, even if TP Racing said it first,
Okay, so we've
adopted the statement as its own.
Right, so we've got a statement on an agency website that we're commanded specifically to give no deference to. So that is likely a conclusion of law, because the question is whether or not TP is a sports franchise under the statute, right? That's a question of law?
Correct, Your Honor.
Okay.
Correct. But the department's statement is consistent with other authorities on this precise topic. In other states like New York and Arkansas, the right to operate a horse track is expressly designated as a franchise. The classic definition of a franchise is a right or privilege granted by the government that is not enjoyed by citizens as a matter of common right or common law. So a horse racing franchise necessarily fits within that definition because it involves gambling and thus requires permission from the state to be operated. It's also consistent with a statement made by the federal tax court in 1952 where it discusses the right to operate a racetrack in Phoenix, Arizona, and labels it as a franchise. That was 70 years ago. And it matches up perfectly with the department's statement that Turf Paradise is one of Arizona's first sports franchises, because I'm not sure that there were any other professional sports in Arizona at that time.
Counsel, I'll remind you, you have about 3 minutes left.
Okay, thank you. And that brings me to my final point, and that is the court erred in concluding that a sports franchise is a right to field a team in a league. And again, that conflicts directly with the language of the definition of professional sport in the Act. The word team is not even mentioned anywhere in that definition. And the definition also not only includes sports played in leagues, but sports played as a matter of organizational play for its respective sports. So the court read restrictions in the statute that simply are not there. The requirement of playing on a team in a league is not part of the definition, and therefore the Superior Court inserted restrictions that simply do not exist in the statute and effectively rewrote the statute and violated the fundamental principles of statutory construction. And if the court has no further questions, I'll reserve the balance of my time for rebuttal.
Thank you, sir. Mr. Irvine.
Thank you, Your Honor. May it please the Court, Patrick Irvine for the Arizona Department of Gaming. The dispute does come down to the statute. What does the statute mean? The department did not rewrite the statute. It took the statute that was given to it by the legislature and has attempted to apply it within the context of the language of the statute itself. The words are there. You interpret the statute as a whole, considering where things fit in. The department looked at sort of the key term here, which is sports franchise. It provides for a license to be given to, there are a number of qualifications, but primarily to a professional sports team or franchise. It's admitted that it's not a team, so it comes down to really what sports franchise is. The department looked at the context of the statute and tried to determine what does that mean, and looked at the things that you look at to determine what it meant, starting with dictionary definitions. As we cite in the brief, sports franchise has a specific meaning. Franchise is a very broad word. One of the citations we have notes that it's unusually broad in different ways, different meanings. But for sports franchise, which is actually the term in the statute, it generally means a team or a right to field a team.
So let's talk about golf and motorsports. Those are individual sports.
Yeah.
How are they authorized to have a gaming license?
They're specifically included.
So if we had said horse racing, we wouldn't be here.
I don't think we would be here.
And what do you think the motivation, if you just had to think esoterically, was behind excluding horse racing from the group that is authorized to have this license?
I should correct myself. I think if horse racing was just included in the definition of professional sports, I think we'd still be here because we'd still be arguing over what professional sports team or franchise means. But in terms of the only reference to horse racing in the statute is in the definition of limited event wagering operator in 51301. That's the only reference to horse racing. There's references to racing enclosures and off-track betting, but to the extent the statute contemplates and includes in its coverage horse racing, it's under the umbrella of the limited event wagering. Why did they do it? We can't really tell necessarily because that's what the legislature does. I think one of the theories actually mentioned by the appellant in the Superior Court was that why did they leave out the only activity that already does gambling, the only sport that already does gambling, which is horse racing? Maybe that was the intent, to give the new licenses to the professional sports teams that didn't already engage in gambling. So that's football and baseball and basketball. The intent seemed to be, by defining it as a sports team or franchise, to encompass those, and then carve-outs for the PGA tournament and the NASCAR tournament. They're included in the list of professional sports, but it doesn't actually track through the statute as to being necessary to give them their licenses, because they are specifically included in the definition of who gets a license. Again, the intent may very well have been to give those licenses to people that aren't already engaged in gambling. The limited event wagering, which specifically reference horse racing, is the way the legislature wanted to include horse racing in this scheme. Scheme may not be the right word, but this structure of providing for event wagering. And so you take the statute as a whole, as the department did, looked at the dictionary definitions, and it looked at the context, which is, the context is, you've got to be a sports franchise, team or franchise, you've also got to engage in league or organizational play. That's generally going to involve teams. The teams may call themselves franchises, but it's going to involve teams. And then you add in the provision for limited event wagering, which specifically includes horse racing. And the department's interpretation of sports franchise as not including the ownership of a racetrack makes sense. And that's the logical interpretation of the statute. You don't have to rewrite it that way. It's the way the legislature wrote the statute. Whether it was presented to them as a package by the governor or not, it's the legislature passed it, the governor signed it. That is the law the department has been tasked with enforcing. And it has no personal stake in this. As Judge McMurdy mentioned, there are only 8 licenses issued. The department would issue 10 if there were 10 qualified applicants.
So you're suggesting the fix would be a fix in the legislature, not here?
Absolutely.
All right.
Because, again, how do you then reconcile the legislature's clear intent to deal with horse racing under the limited event wagering license category with also including them in the event wagering? The legislature might have to adjust the statute in different ways that the court could not. In answer to the question, can you be both an event wagering operator and a limited event wagering operator, I don't know. But the statute defines limited event wagering operator as someone that partners with an event wagering operator. I would interpret the word partner as implying that they've got to be separate somehow, even though the limited event clearly focuses on location as opposed to the identity of the organization that operates it. An event wagering operator, as noted, can have a solid location, but also has the mobile apps that we all see advertised now. Whereas a limited event wagering operator just has fixed locations, like an off-track betting or a racetrack itself. And TP Racing has been issued a limited event, or at least a temporary one there. So in terms of the way the statute's been provided, that's the way the department's interpreted it. I think the key term is sports franchise. And as I've gone through, as the brief goes through, the department has looked at the dictionary definitions, it looks at the context of the statute itself, and just determined it does not include a racetrack owner. Yeah.
And that definition works much better when we're talking about the Cardinals or the Diamondbacks or the Suns. It's a little bit more difficult to parse when we're talking about the PGA and a golf tournament where individuals play, or NASCAR when you're talking about individual teams that compete against each other in the NASCAR forum. So I'm having a little bit of trouble distinguishing between the two, and just anything you can tell me on that point to make it more clear in my mind what the difference is.
Between sports team or franchise and the PGA and NASCAR? Yes. Yeah.
Actually, between the PGA and NASCAR and Turf Paradise, what's the difference between them structurally, and why are some franchises and Turf Paradise is not?
Those others are not franchises. The term sports franchise is not necessary for them to have a license. They are specifically included in the definition of a event wagering operator, and the statute specifically provides that they will get a license if they meet the other criteria.
The only thing that TP Racing needs to do is amend the statute to include them in that section, and we're all good.
Absolutely.
We're not fighting over franchise.
You're not fighting over franchise. If the statute did not specifically reference the PGA tournament or the NASCAR, and they were, I shouldn't prejudge this, but in terms of if they were applying for a license saying they were a sports franchise, I think the Department of Gaming's answer would be the same. You're not a sports franchise, because the definition of a sports franchise is a team or the right to field a team, and that doesn't apply to NASCAR or PGA tournaments, even though you may be a sport. So I think the answer to them would be the same, except the legislature put specific provision in that they get a license regardless of whether they're a sports team or franchise. That's just in there. And so they applied, met the other criteria, and that's what happened. They were issued it. And so, but in essence, again, they're not a sports franchise, and that's the definition. The argument is that the disjunctive somehow makes the definitions different. If you even look at the authorities that they cite, the parents involved case, it notes that that doesn't mean there can't be overlap. It can be one or the other or both. Case that I found from this court, EHV Slayton, 245 Arizona 331, paragraph 4 from 2018, distinguished between exclusive versus inclusive disjunctive. A lot of grammar rules. But it noted that inclusive disjunctive means one or the other or both. And that's what we have here. Team or franchise does not mean completely distinct definitions. There's a lot of overlap, and that's really what the legislature meant. The record does show that other organizations refer to themselves as franchises. It's included in the footnotes in our brief, which were also included in the record before the administrative law judge, so it became part of the evidentiary record there. And in terms of the department website, it's not authority. There's just no legal authority to even apply it. If the legislature was even aware of that, and they thought that that should give some leverage to that include TP Racing, a racetrack owner, as a franchise, you would have thought they would have then included horse racing under the definition of professional sports, but it's not part of that list. So it really has no legal effect. So just in conclusion, if the court has no further questions, the lower court should be affirmed. Thank you.
Thank you, Mr. Irvin. Mr. Schulte.
So, Mr. Irvine mentioned the Black's Law Dictionary definition of a sports franchise, but that definition is far more narrow than the actual definition of professional sport that's contained in the Act itself. And that's what this court must interpret, is the actual definition in the statute of a professional sport. It does not mention the word team. It includes, as examples, sports that are not played on teams. And it also is not limited to teams that play or sports that are played in leagues. It includes sports that are organized or played for organizational play for their respective sport. And that's what horse racing is. It is organized, partly by governmental regulation, chiefly by the racetrack operators themselves with the participation of the actual competitors. But that's really no different than how other sports are organized, like the NFL. The teams owners or franchise owners get together and they debate changes in rules and schedules and things, but the commissioner ultimately makes the decision. Well, it's no different here, and the record reflects that. The racing meet dates are set by the franchise owners with discussions with the Horsemen's Association, but they ultimately need to be approved by the department. But that is how the sport is organized for its respective sport. It fits squarely within the definition of the statute. And so this court must interpret the statute as written, not as the department would like it to have been written, because this is a de novo review. And I see that my time is up.
Thank you, counsel.
Thank you.
We appreciate your arguments. We will take this matter under advisement and issue our decision in due course, and the court stands in recess.